Good day everyone, welcome to another episode in our What If series where we bring you insights in the format of a what if question on the ever-evolving landscape of employment law. I'm VP Moolman from Maserumule, and in today's episode we will unpack what if a fixed-term employee dismissed for misconduct had their contract expire before an unfair dismissal ruling. Can this employee be reinstated? Now, as a departure point, let's look at section 193 subsection 1 of the LRA. In terms of this section, an arbitrator has a discretion to either order an employee to reinstate, re-employ, or compensate an employee whose dismissal is found to be unfair. Section 193 subsection 2 provides that the labor court or the arbitrator must require the employer to reinstate or re-employ the employee unless 1. The employee does not wish to be reinstated or re-employed. 2. The circumstances surrounding the dismissal are such that a continued employment relationship would be intolerable. 3. It is not reasonably practicable for the employer to reinstate or re-employ the employee. Or finally, number 4, the dismissal is unfair only because the employer did not follow a fair procedure. So it is well established that when a dismissal is deemed unfair, specifically substantively unfair, the primary remedy is typically reinstatement, unless indications from the mentioned factors propose a different approach. But nevertheless, there are situations where reinstatement is unfeasible despite the absence of any of the mentioned factors, as was the case in the matter that I will be unpacking. Now, the case I want to discuss is Toyota SA Motors versus the CCMA and others. It's a labor appeal court decision that was handed down in May 2023. In this case, the Labor Appeal Court found that the reinstatement of an employee was not an option. Let's look at the facts. The employee, or ex-employee at least in the question, Mr. Twala, commenced his employment with Toyota as a crane driver beginning March 2010 on a 3-month fixed-term contract. His contract had been continuously renewed until his dismissal on 14 August 2015. It was common cause that on the date of his dismissal, the employee's fixed-term contract would have expired on 31 October 2015. Mr. Twala, unhappy with his dismissal, referred an unfair dismissal dispute to the CCMA seeking retrospective reinstatement. Now, at the CCMA, the Commissioner found Mr. Twala's dismissal substantively unfair, and in respect of the remedy, the Commissioner did not accept Mr. Twala's version that he was to be made a permanent employee and instead considered the fact that at the time of his dismissal, Mr. Twala was on a fixed-term contract which had expired on 31 October 2015. The Commissioner accordingly held that because Mr. Twala's fixed-term contract had expired, reinstatement was not possible. He was instead awarded 2.5 months compensation, which was the period remaining on his fixed-term contract. Mr. Twala was of the view that he should have been reinstated and therefore took the matter on review to the Labour Court. Now, the Labour Court granted Mr. Twala's reinstatement and in this regard held that in terms of section 193 subsection 2 subsection C, it behoves an employer to establish that it was not practical to grant reinstatement. In this case, the Labour Court said Toyota failed to adduce any evidence to discharge such an onus. The court found that the arbitrator misdirected herself in placing the onus on Mr. Twala to prove that the reinstatement was practical. Now, Toyota appealed the Labour Court's decision to reinstate. And the Labour Appeal Court acknowledged the fact that when awarding a remedy, an arbitrator exercises a discretion. However, in this case, and on the basis that the fixed-term contract had expired prior to Mr. Twala's dismissal being found unfair, the arbitrator's discretion was removed. The Labour Appeal Court said the following: integral to the exercise of the arbitrator's discretion in terms of section 193 subsection 1 in deciding whether to reinstate, re-employ or compensate an employee is the nature of the employment contract and whether it is extant when an employee's dismissal is found to be unfair. The remedy of reinstatement is confined to the situation where, at the date of the finding that the dismissal is unfair, the original employment contract is still in existence. However, where the employee is employed on a fixed-term contract, the expiry of which precedes the unfair dismissal finding, as in this current dispute, then reinstatement or re-employment are not legally permissible remedies. In the circumstances, the arbitrator no longer has a discretion to choose between the three remedies contemplated in section 193 of the LRA, but is obliged in law to order the employer to pay the employee compensation in terms of the same section. The arbitrator was therefore legally precluded from awarding reinstatement, and the Labour Court made an error in finding that Mr. Twala should be reinstated. So, colleagues, in conclusion, the importance of this case is that when a situation arises where an employee's unfair dismissal is determined, yet the employee had been working under a fixed-term contract that concluded before the ruling of the unfair dismissal, the option of reinstatement as a remedy cannot be awarded. This is because the arbitrator or court would essentially be forming an employment contract on behalf of the parties. Now that then brings us to the end of this week's episode. Thank you for joining us. We hope you found our discussion informative. If you have any questions or comments, we would love to hear from you, and you can always find us on social media or email us at info@massconsulting.co.za. Until next time, bye-bye.